And last but not least, John Morrow from Knight, Nicastro, MacKay. He is an experienced litigator who handles pre-suit matters and active litigation in Missouri, Illinois, and Arkansas. His areas of practice are civil litigation, insurance defense, arson fraud litigation, and pre-suit first-party matters. So that is all I have for housekeeping items. If you all would like to take over, we'll start with depositions and we'll move on to mediations. If John or Erica would like to start us off.
Would you like me to start?
Go ahead.
Okay. Well, yeah, and I think that's the first topic on the agenda is the depositions. And I just kind of had a few notes and then we'll kind of open it up for questions. I think coming from the defense side, I have a certain perspective. I think Erica does. I don't think there's going to be too much fighting about it, but I think I think there is a different perspective on both sides. Traditionally, I would say there has been some hesitancy to utilize the technology by my clients and then also just by lawyers in the defense bar. I think a lot of people pictured it as sort of a Skype call from 1998, sort of just, you know, where a lot of breaking up, not being able to hear the audio, that type of thing. What I do think, you know, one small advantage of the pandemic is that everyone is now more familiar with the technology, utilizing the technology. You know, grandpas and grandmas, as frustrating as it can be, everybody out there, young and old, is utilizing this technology and seeing its possibilities. So I do think that the door is open for utilizing video conference depositions a lot more moving forward, even after we're able to get out of our homes and into the sunshine. But what I would say from the defense perspective, I just don't think it's ever going to be a one-size-fits-all type of thing. One thing that I would worry about is that, you know, sometimes with larger clients, sometimes the decisions on how things are conducted are made by bean counters and some sort of directive that only videotape depositions or only video conference depositions will be had because it's a cost-saving measure. I think it would be a mistake. What I do think would be a good idea is to look at it from a more nuanced perspective and look at it as something that is very practical for the right situation, and that the technology is there to save money. And then also, you know, it also has other advantages as well. But again, you know, for something that is document heavy, very, very document heavy, where you really need to be right next to the person, showing them things the entire time, thousands of pages, things like that. I don't know if that's the best. It can certainly be done, and there's strategies to get it done, but I don't know if that's necessarily the best option for you. Now, something that's lower exposure, something that where there's no documents, I think it is an absolute perfect fit. Also, you know, some of us out here, you know, I work in several states. We do have depositions that are not as important, that are further away in Arkansas or across the country or, you know, somewhere else. And I think the technology is perfect for that. You also get into situations in my work, and this is where it's been, you know, very helpful in the pandemic, where I have some pre-suit matters where things need to move a little bit faster. And practically right now, in a lot of states, I can't meet face-to-face with people, or maybe people are unwilling or they're in a high-risk group, but the work still needs to be done. And I think that the technology absolutely is perfect for that, and to move certain matters forward that need to be moved forward practically. Because the option isn't that you throw up your hands. I mean, you have to actually, you know, move the case forward. And I think in the right situations, and I think there's more than people realize, that the video depositions or the video conference depositions are perfect. And you know, for example, you know, I think, I mean, one, I think there's several advantages to it. I think that you have a situation where if you don't have a lot of documents, you can get the deposition done quicker without with fewer scheduling hassles, fewer travel hassles. Also, practically from my standpoint, I have clients that like to attend depositions, that like to see what's going on, that want to be part of the process. And one thing that I like about this video technology is that they can also attend via Zoom. I had actually a live deposition down in Arkansas where the client actually attended and watched via Zoom, and that was a pre-suit matter. And that had several practical effects. I mean, obviously, always two heads better than one. But then, you know, there are certain clients that really do want to be more involved in the process. Also, you might have a case where you do want your client to attend, such as a pre-suit matter, an insurance dispute, where you want the claim handler to be able to see the witness, to assess them as a witness, because they are the person ultimately making the decision. So from a practical standpoint, that's perfect use of the technology. And then, you know, I also think, and just keep this in mind, yeah, you don't get that across the table feeling. And sometimes, you know, I have a certain flow. I think everybody here at the table probably had a certain flow for the way they took depositions. And I think that can kind of break it up. The video technology, there's a feeling. What I will say from having to conduct these things during the pandemic and statements and things is that oftentimes it's not as formal, and you can use that to your advantage. You're talking to somebody that's in their bedroom and they feel a little more comfortable than coming to a law office, you know, in some sort of high rise sitting at a long conference table. And that comfort can sometimes get you the information that you want. You can make it more conversational if that's your style. And I think you can use that to your advantage. So, I mean, those are all things I see as positives. That's kind of just my initial spiel. And maybe I can turn it over to Erica kind of for her perspective on, you know, how the plaintiff's bar is looking at this too.
Yeah, absolutely. So for the past probably 15 years, video conference depositions have been something that our firm has utilized. And, but even for me, and I will self-classify as an elder millennial, familiar with technology and comfortable with Zoom meetings and things like that, my practice has changed in regard to taking video conference depositions pre-COVID versus post-COVID, and I'll explain that. So in the past, when I've chosen to do a video deposition, I would go to our office and utilize the technology in our firm. Our conference rooms are fitted with TVs and a camera under that TV to be able to project us. And I end up being this little person at a table in a room, depending on if you've been on the other side of a deposition with the Simon Law attorney, you may know of our North Conference room where I am like in the dark, kind of. But that's how I did those depositions. I never did them from home. I never did them on my laptop. I handled exhibits by sending them ahead of time, organizing and sending them ahead of time to the court reporter, who would have them printed out, and he or she would hand those exhibits physically to the witness that I was on the other side of the video feed with. So obviously, since we have post-COVID, in the aftertime, since we've been taking these depositions at home and doing everything remotely with all parties, often including the court reporter, remote, that has really changed the way that we've used exhibits. And that, I think, has been one of the staunchest learning curves for all attorneys using Zoom technology or other video conference technology to get over when you're deciding whether to take a deposition by video or not. I will say, from the experience with the COVID pandemic and trying to get through the initial logjam of how are we going to go forward with what we need to get done in our cases. You know, how long is this going to last? Is this something where we can postpone this deposition a month so we can do it in person? Unfortunately, now we've learned that you know, I think everybody there was a sea change where everybody got on board as far as, if we're going to keep our cases moving forward, we need to get used to this technology and the, you know, at least perceived uncomfortableness that came with that initially. Also, the St. Louis City and County put out some orders regarding video depositions from the presiding judges, saying they expect and anticipate things will move forward when video depositions can be taken. So that was an important step as well in encouraging all of us to utilize this technology. Obviously, as a plaintiff's attorney, I have more autonomy with the decisions that I make regarding taking video depositions. It is a benefit that I have, that I get to make that decision really from my own human costs, whether it's traveling for an expert or whether I think, you know, maybe I have an early hearing the next morning when, you know, I might need to be in Denver for an expert the day before. And if I can change that to a video conference deposition, then obviously I don't have the issues of travel. That's how I used to make decisions about video conference depositions. And now I make that decision based on moving cases forward. And I think the change that I've seen, at least from a practical standpoint, which I'm sure a lot of you have tuned into this to really get some practical tips about using the technology and how we've worked with it. There are two scenarios that are important to how you use exhibits. One is the scenario where everyone is remote and you will likely be sharing your screen to use an exhibit. And the other scenario, actually a setup that I even did at Alaris, I was remote, one of the other attorneys were remote, and the deponent, the court reporter, and the defense attorney were actually at a room at Alaris before their own office had reopened. And I agree with what John said. In that particular deposition where half the crew was at Alaris and half of us were remote, just as a side note, in that case, my clients are actually in Australia, and they were able to tune into the deposition, which they were interested in. It was the defendant in a wrongful death case of their father. And they did want to hear from him and learn what he had to say. So they were able to tune in remotely, which, as you said, that was a really good benefit of that technology. So going back to the scenario where everyone is remote, I have learned that test driving your exhibits, test driving your technology, and making sure you've given yourself enough time to do that, especially if it's not something that you're extremely familiar with, or you're doing you know, remote exhibits for the first time. Make sure you're comfortable with that. Find someone, and I'm sure Alaris has some resources for this as well, but find someone who will give you a tutorial if you need it, as far as what functions you need to understand how to use on the video conference. My solution for exhibits are to pre-mark them, have them in separate PDFs, and keep them on the desktop of the computer that I'm using for Zoom. I use a different screen for my Zoom meeting as compared to my computer that I'll have email and things on, so I can have both screens going and not try to be jockeying between, you know, my Zoom window on my screen and maybe something else I need to access. So if you have your exhibits in PDF saved on your desktop, on the computer in which you're using the Zoom platform, you can use the share screen function. And if that's not something that you're comfortable with, I have also found that when I have set up depositions that also are being video recorded remotely, the videographer has run my exhibits for me, actually. So I can call them up on the screen and not physically have to be bringing them up myself, which I think I'd be comfortable. I'm comfortable, and I've done that in some depositions, but in kind of those higher stake ones where I'm staying very focused on my line of questioning, I will call them up from either the tech or the videographer that is also logged on to the Zoom meeting, and they have shared their screen. So that's a great option if you are not comfortable, or it doesn't sound like something you'd be comfortable doing, calling up your own exhibits. But it can be done as well.
How far in advance have you been sending out your exhibits to the videographer to be able to do that?
So as far as how early to send out your exhibits, I mean, I think we can all agree that day to day you are prepared in advance as much as possible. I like to do that the day before, but really that process for me happens when I'm preparing for the deposition. So even if I'm preparing for a deposition a week before I were to take it, I will send along my exhibits the day before in case I change them or change the way I want to use them. I also don't think it's a problem to go ahead and pre-mark your exhibits, and it doesn't matter if you end up using A and D and F, or 1 and 4 and 6, that's fine. That is all, you know, your own organizational style. So I err on the side of marking what I think I'll need and then using only what is called for in the deposition.
We do have a question that's relevant to this, if you don't mind, sure, before we move on. So the question is, can the attorney set up the Zoom deposition and send the invites to the parties, the court reporter and the witness, or should it be done by the court reporter? I'll jump in and say yes. What if the court reporter doesn't have a Zoom account? So I don't know if you guys want to answer that, or if you have an answer for that.
Well, I don't know if they don't have a Zoom account. It's what I will say, it's very easy. Now, if for some reason you I think Alaris has plenty of reporters they have a lot of Zoom accounts and licenses. You know, I know that there is, and just so everyone knows, the free version of Zoom, they do have a time cutoff. If anyone's never run, 45-minute time cutoff. So, and, you know, so you got to be careful of that. I would say, you know, if you're from the court reporter's perspective, if for some reason you don't have the licenses or the attorney wants a different platform, I would say in that situation, maybe you should be the person, or the assistant or paralegal on the file should be the person sending out the appointment under their account if there is some limitation there. But as far as I'm aware, I mean, Alaris and everybody else, they have the technology. They should probably be sending the appointment because a lot of times, I mean, yeah, I think they should kind of be the moderator. You don't really need a moderator, but I mean, as far as the person kind of starting it, ending it, court reporter is usually probably a good starting point as far as that. So
yeah, and the time. So yes, the depositions we set up through Alaris, they've sent us the Zoom link and make sure that everyone has it, and so I just have to log on. The time where I scheduled and hosted the Zoom meeting myself has been when my expert was testifying in Denver, and the defense attorney opted to travel to Denver. This was at the beginning of this month, and I opted not to. And so the court reporter was scheduled by the defense attorney, and I sent the Zoom link so I could attend remotely, and my expert, who was an engineer, so I thought he could handle it, he hosted the Zoom meeting on his laptop, and that worked fine. So like John said, the court reporter should be able to set that up, and you have the option to do that if maybe you want to link in the other situation where you might be the only one attending remotely.
And my only other note is I've had situations where I did actually set it up for the clients to attend, and then actually Alaris has been great and set up those links as well. So whatever you need to do, I think most court reporting services can set that up for you. And then, yeah, and one other plug for Alaris, just something that Erica reminded me of, that having multiple screens, I think, is imperative if you're going to be using exhibits. So if you don't have that set up at home, there is conference rooms with the big TVs, and you know, the law firms have that as well. But if you have a conference room where you can have the witness on the screen and then have your laptop in front of you, I would highly recommend that, because switching between the video and then trying to share things and the share screen, it's too much. Things get confused, things get missed. So I would highly recommend whatever your screen setup you prefer, but you have that ready and maybe even test it. But the easiest way that I've had it is a conference room with a large TV, have the witness up there, have your laptop in front of you with the exhibits ready to share. And then if you have an outline, just have that printed out, sort of thing. So that's what I would recommend as far as that, just practically. And then for the larger exposure cases, as far as exhibits, I don't see any problem with even getting a paralegal or someone else involved to help you with that too, and make the process go even smoother on their own laptop, because that's a possibility too, for them to have a Zoom link where they're sharing their screen. And I think there's practical solutions to some of these problems. Earning my gray hair, I do still prefer having the documents sometimes in front of me, but I think there are ways to do this to make it move forward, and everybody has the same documents in front of them. They're all bait stamps. You can get to them. You can also, there is the technology. I mean, like for a PDF, if you're sharing a PDF, you can still use the Adobe features and highlight certain things. I mean, keep that in mind. You can use the features of whatever the program is still. Don't limit yourself. So if you're looking at a certain medical record with smaller text on a larger piece of paper, highlight it either before if you're going to need it, or if you want to ask a couple questions and then highlight it. And I mean, you can do that. So I think you just think it through, though. Don't be limited, though. They can do a lot of things. Ask Alaris questions, ask other people who've done questions, because, hey, I want to do this during the depo. A lot of times it's possible. It's possible to share video. I mean, it's possible to, share audio. It's possible. So just think it through, ask those questions, because obviously every deposition is different. And, we're just more used to doing in person, but there are practical solutions to some of these problems that are brought up, either a lot of documents, or I like to mark things. I like to do different things. There's ways to get around that. So.
Yeah. And another thing I thought of as you were talking, when you're deciding whether to do a deposition via video or wait to do it in person, or if you're comfortable doing them in person now, one of the things that I think is really interesting is I've heard from a lot of defense attorneys that, it needs to be in person because it's a really important deposition. I don't make the same calculus. I think it's giving sometimes all of us a little bit too much credit that, being in the same room with a person, that you're going to perceive something that you won't be able to perceive on video. I've actually found the opposite. You feel a tone change over video depositions the same way you might if you were in the same room. Yes, there's a little, obviously there's a bit of distance and things you might not notice. And I understand that, that's a calculus that you need to make with your client. But I will tell you the one time recently where I changed that determination. I had a case where we were taking party depositions, and without giving too much away, it involved teenagers that were involved in a vehicle versus pedestrian accident. It was extremely traumatic for both of them. Obviously, I'm representing the injured person who is having a really difficult time even dealing with that and talking about it. And I knew that having to interview and grill the other deponent who was driving the vehicle was going to be a very difficult thing for these kids. So with, the agreement and talking through things with the defense attorney, we agreed that we wanted to do everything to facilitate those depositions in person, which we did last week. And that was the right call, because that, thinking about the human interaction and things like that was important. But, if I'm going to be deposing an expert or even presenting an expert in some cases, that's something that, doesn't have that factor available. So that's one of the things that goes into my own calculation of video or in person, especially during this time.
Yeah, and I think, well, and everybody's going to have practically, I have postponed depositions because the other side is not comfortable with the video technology. I have also insisted on certain depositions that I want later to be live, just based on my own personal metric preference. And I think, there's going to be some fights down the line. I think everybody's being pretty reasonable right now as far as, if you want to delay something, just don't, we got to move the deadlines. We got to do other things in order to accommodate that. For any of my stuff that's, pre-suit, we just got to make sure it's clear that you guys are requesting the delay and things of that nature. So, and I'm aware of those personal preferences. I do think that people have to have a little bit more of an open mind to the technology moving forward, because I think, I think it's a practical solution, one that saves money. And, I think they have to be more open to it. One thing I do want to note as one of these practical tips, there's one district court, a Kansas decision demanding a live deposition that I'm aware of. I am not aware of any other orders from any district courts or courts saying that someone has to appear live. I do think that we are going to have orders that address the issue. So watch out for those. Make sure you're making yourself aware of those issues and those orders, because I think, sometimes attorneys can't get along and they'll just take that to the court. I think that would, as a judge that's just going to bother the judge, but so I would probably try to avoid that. But certain attorneys are going to bring that up. There's going to be orders out there, and we're going to know the answer soon enough for whether or not these things have to be live or by video conference.
So if we want to move on, I think for a little bit to Tom, and we'll talk about remote mediations, and we will definitely come back to depositions. We do have some questions we'll try to get to. So go ahead, Tom.
Given the pandemic, jury trials have not been held, and I'm not sure when they're going to be held. What I'm seeing are more cases being mediated that wouldn't ordinarily be mediated because they don't know when they're going to be able to show up at trial. So the question is, should you do a Zoom mediation or should you not? The answer is you should do it unless there are reasons why you shouldn't. Some of the reasons why you shouldn't are if you don't have a comfort level with the technology. The lawyer sometimes doesn't have a comfort level. That's easy enough to overcome. Sometimes the client doesn't have a comfort level with the technology, and that's more difficult to overcome. So before you schedule a Zoom mediation, make sure your client has a comfort level with the technology. Some clients, especially in cases like Erica was discussing, some older litigants need a child, a grandchild, a cousin as a support person. As a mediator, I strongly encourage plaintiffs, especially, to have a support person with them if they need it. That's hard to do in a Zoom mediation unless the support person goes with the client, stays in the room, and participates by Zoom. Some clients need to have more support from their lawyers than other clients. I'm seeing mediations where the plaintiff's lawyer is in one room, the plaintiff is in another state. It's hard for the plaintiff and the client to have a personal communication during the Zoom mediation if they wait for me to leave the room, the Zoom room, the breakout room, and they talk over the screen. Some clients just need the personal support of their lawyer, and those things probably shouldn't be done by Zoom. Second reason not to do it, logistics. Do you have the bandwidth to do this? When you're at home and your children are not in school, your children are on platforms, your wife can be on a platform, your husband can be on a platform. You just don't have enough bandwidth for all these people to be using all these platforms to get through to the internet. Some people live in rural areas where the reception, the cell towers aren't quite good enough. Some people don't have the equipment. They don't have a laptop, they don't have a desktop. I had a mediation yesterday where one of the people attended by cell phone. I have to tell you, there's not a roller coaster in this country that can duplicate the effect of trying to deal with a person in a mediation on a cell phone. I have had a person attend a mediation in a car with a cell phone. Please don't do that. And if you're the lawyer and you're setting up the mediation, make sure your client understands how serious it is. They be at a place with a fixed iPhone, if they have to have an iPhone or an iPad or a laptop. Some mediations you do have to have face-to-face, in my opinion. And those are cases if there are psychiatric issues, cases if there are sexual injuries. Those do not lend themselves to discussing over the internet. These things can be hacked. I haven't had experience with that. But there are things that are so personal, the people who discuss them should be discussing them in the privacy of a smaller room where they're absolutely, positively guaranteed the only people listening are the lawyer and the mediator. How to set up a Zoom mediation. And I'll tell you something that is surprising, but it's true. Figure out what time it is. You get standard time. I see notices, the mediation will be 9 o'clock Central Standard Time. Well, it's daylight saving time. And years ago when Indiana used to have daylight saving time, some parts of it were Eastern Standard. You wouldn't know what time it was if you weren't from Indiana. If you have adjusters from the West Coast or the East Coast, make sure they know what time the mediation starts. What platform? Is it a desktop? Is it a laptop? Is it an iPad? Is it an iPhone? Make sure their equipment is compatible with the type of Zoom presentation Jen will send out from Alaris. Zoom allows you to pick a background. Please pick one, anyone. I don't care what it is, but stay with it. I have had experience with a person who change the background every 10 seconds. Thought it was really clever. It's not. It's distracting. So pick a background. In my experience, the blander, the better. You can have a big American flag if you want. You can have the Court of St. James if you want. Please don't do that. Have a simple background that doesn't detract from the seriousness of what it is you are trying to do. Make sure your equipment can accept the email invite or the calendar appointment Jen has. She will send you an email which will have a meeting URL, an ID, a password. You need to log on to all those things, or she can give you a calendar appointment where you just click on it and it takes you straight to Zoom. If you haven't done it, do it before it's your mediation. And I'll come back to that in a minute. Tell your clients they can rejoin the mediation if they, for some reason, are having trouble, they have technical difficulties. They just sign out, start the process over again, and they'll come back into the waiting room and the mediator can allow them back into the general room and then into their breakout room. Do a dry run if you can. John mentioned that Zoom has a free mediation service that only lasts 45 minutes. Have a couple of your friends, a couple of your office mates say, look, let's all three of us get on a mini Zoom, test out things, get the volume straight, get our pictures straight. Adam here says, put your hand over your head. That's how much space should be between the top of your head and the top of your frame. You don't want to be too close to the frame. You don't want to be too far away. So those things are all things you can practice, and they're very easy to practice ahead of time. If you need to, shadow someone. If you are going to have a Zoom mediation and you've never had one, call Alaris and say, do you have a Zoom mediation going on tomorrow, the next day, the day after, where I could, if I'm a plaintiff's lawyer, I can sit in with Erica. If I'm a defense lawyer, I can sit in with John and just see how it's done. See how the keys are punched. What buttons do you push? How does it look from where I am? Where are the things I'm supposed to find out? Just go through a practice. People will be more than happy to let you sit in on some aspects of it so you can familiarize yourself with how to run it. Be sure to teach your client. I've had several of these where the lawyer is very fluent in the Zoom language. The client is not with the lawyer. The client doesn't have a clue what they're doing. They click on the link and they go, well, the first thing you have to do is turn on your audio. Well, okay, it's real hard. And you guide them through turning on the audio. Then they turn on the audio. Sometimes they can't turn on the visual. The lawyer can go through it with them ahead of time so when the mediation comes, they're all up to speed. This is a small thing, but it's very important. Provide your cell phone to the other lawyer or to the mediator. Sometimes your sound will bug out and you don't know it. Your video will bug out, you don't know it. If the mediator has your cell phone number, the mediator clicks it up, sends you a text, your sound is off, your video is off. Or sometimes the plaintiff's lawyer wants to communicate with the defense lawyer and saying, did you really say that? Is Plunkert really telling me the truth? Or sometimes you will be cut out of the Zoom. Nobody will know where you are. You can text the mediator can text you and say, you're bugged out of the Zoom, please reapply. Or they'll say, I had something happen at my house, I will reapply, I'll join you in 5 minutes. Exchange cell phone numbers for texting and for calling. Sometimes I've had this happen too. I've had the attorney want to communicate something to me without his client or her client knowing. So they will text me and say, yes, what my client just said isn't exactly accurate. Where can we go? I can put the lawyer in a separate room where I can go talk just to the lawyer and not to the lawyer and the client. I can put each lawyer, if one lawyer, plaintiff's lawyer is in room 1, defense lawyer is in room 2, I can take each of them and put them in room 3 where the 3 of us can talk without the client or the insurance adjuster being present. If somebody sends me a text and says, I need to talk to you outside the hearing of my client, I come in, I just zip them off to another room, I talk to them, and people don't need to know why it's going on. It just needs to get done. If you are attending from home, please make sure your dogs and children are not in the room where the mediation is taking place. It's very distracting. we will come to another area later on of distractions. There's no end of the list of distractions in a mediation. But when you're live and you're at Alaris, you're in a room, there's really not much else to do. There aren't many distractions. When you're at home, there are a lot of distractions. I don't blame you for falling prey to them, but try not to. Once you begin the mediation, be on time. What happens is the mediator is the host. People come into the waiting room whenever they sign on, and the mediator can accept whoever he or she wants into the main room. I try to accept the plaintiff and the plaintiff's counsel into the main room, chat with them for a minute, and then put them in room 1. Then I bring the defense lawyer, the adjuster into the main room, put them in room 2, and they really never see each other. There's not really much, you can't really see, you can't learn much. The defense lawyer sometimes says, I haven't met the plaintiff, I'd kind of like to size them up. Well, all you're gonna see is their face. So there's not much to size up. So size them up somewhere else. You have to activate the video, you have to activate the audio. It's frustrating a little bit when you think your audio's on and it's not, or you think your video's on, it's not. Again, sometimes you just have to go out and come back in and say, oh, that's what that meant. Check video, using internet video, using internet audio. Again, if you've practiced, those things are not much of a problem. I don't like opening statements. I strongly discourage them, but the mediations belong to the lawyers. If the lawyers want to have one, I will grudgingly accept one. I haven't yet had one by Zoom, but you have to do it in the general room. Everybody's there. The advantage is only one person can talk at once. The other advantage is I can shut off your microphone if I want. That's really quite the advantage. Yeah. How was my presentation? It was great. Nobody heard a word. I shut off your microphone, but that's okay. If you want an opening statement, please let the mediator know in advance you are going to want an opening statement. I generally do the ground rules for the mediation once I put the people in their room, because different ground rules apply to the plaintiff, because the plaintiffs generally don't have familiarity with a mediation, whereas the defense attorney and the adjuster generally do have familiarity with the mediation. So I explain different things to the plaintiff in a little more detail. When you put people in a breakout room, it's very important to tell the client how confidential it is. They are just a little skeptical that somebody can hack into their room, hack into their feed, or somebody is standing just 2 feet off camera from me, listening to what's going on. Assure them it is confidential. When they're at Alaris, they're in a room, 3 people, doors closed, they know it. When they're not at Alaris and everybody's attending with their faces up in the corners, they're really not sure. And this is a question I get a lot. Can the other people hear what we're talking about? No, only the people in this room can hear what you're talking about. So reassure the clients they need it.
Hey, Tom, really
Yes.
quick. We had a question from an attendee about the breakout rooms. I think you pretty well addressed it, but just that they are completely separate and that nobody can move between the rooms except for you or the host.
Yes, the host sets up a number of breakout rooms. I always set up many more than I need in case 2 people want to break off. Once you put, as I say, the plaintiff and the plaintiff's attorney, I'll put in breakout room 1. On their screen, they see each other. That's all they see. That's all they can talk to. Nobody can talk to them. They can't talk to anybody else except the 2 faces on the screen. When I have a button where I can join breakout room 1, I click the button and then 2 faces become 3. And they look and go, oh, how are you? Tom's here. Yes, I'm here. There are 3 of us in the room. Nobody can hear us. Nobody can tap in and say, I want to talk to you. You want to talk to me. Just the 2 people in the room can hear it. When I back out, when the plaintiff's attorney says, I'd like to talk to my client, I back out, I go to the main room. There is a button that says, need help, ask for help. In fact, it's the next thing on my list. You scroll down to the bottom, there's a button that says ask for help. You click the button, it sends the host an email saying, breakout room 1 needs to talk to you. That's how I know I can come back in the room, not interfere in your conversation. I come in when you want me to, and not before. I'm not coming in the room saying, are you ready for me yet? What's taking so long? They'll call me when they need me. And anybody in the mediation can do that. Anybody in any breakout room can hit that button and it says breakout room 2 needs to talk to you. Breakout room 3 needs to talk to you. Fine, I know I can go into that room because they want me to come in and they're expecting me to come in. If your microphone is on mute, Jen taught me this trick, this is great. Sometimes you want to keep your microphone off because you're talking to your child or you're talking to somebody on a cell phone call and the mediator comes in. If your microphone is on mute and you hit the space bar, you can talk. It breaks up it interrupts the mute button. So some people will just stay on mute if they have a cold and they're sneezing and they're coughing, or there's someone who's a third part, they're not the defense attorney, they're not the adjuster, they're a third person, and they say, I don't want anything I say to just happen to wander over the airwaves. Turn their microphone on mute. You hit the space bar, you can talk. It's a handy thing to have. Once you put the people in the breakout rooms, it's important for the mediator to make the rounds. Get in each room and say, you're in room 1, you're in room 2, here's what I'm going to do, what I call provide them a roadmap. Tell them what's going to happen. I'm going to talk to the plaintiff's attorney and the plaintiff for about 10 minutes. Then I'll come talk to you. If you need me, hit ask for help. But it'll be about 10 minutes. And I go, oh, sure, 10 minutes? Okay, fine. When you go to talk to the defense attorney, tell the plaintiff, here's where I'm going to go. Here's what I'm going to do. I'm going to try to get you some more money. So bear with me. It's going to take about 10 minutes. And they go, okay, that's fine. Any questions before I go? No. They know what to expect. This is something else that you can address in the breakout room. Where people are sitting on the camera, are they off center? Are they too high? Are they too low? Is the camera too far away? Is it too close? Is it too dark? Do they have the shades pulled down? Are the shades up? Is it too bright? Do they have a ceiling fan on? Turn off the ceiling fan. It's very distractive, and the IT people here tell me it can interfere with the signal. Are there children running around, dogs running around? You're at home. I understand that. It's comfortable. Close the door. Even if you just close the door while you're talking and you want to leave the door open while you're not, close the door. If you want water, bring water with you to the mediation. You will need it. A number of times I go back to talk to the defense attorney. There's an empty chair. Where is the lawyer? I don't know. So you wait, oh, you're back already. Oh, I was just in the other room. You know, stay where you're supposed to be. It's your job. The negotiations. The negotiations through the mediation to me stay pretty much the same as an in-person mediation, with one exception that Erica touched on earlier. You do not get a personal vibe. You do not get a sense of momentum with a Zoom mediation. When you're in a room with a plaintiff who has been injured, it is possible for the mediator to forge a little bit of a relationship with the plaintiff so that later in the day, when the mediator says something the plaintiff doesn't want to hear, the plaintiff will say, well, I kind of like this person. I kind of trust this person. I'm kind of getting along with this person. So if this person tells me that this part of my case isn't good, you know, maybe he's right. It's hard to do over a Zoom. It's very hard to do. A sense of momentum is hard to do because you're clicking in, you're clicking out. They don't know when you're coming back. They don't know really when you're leaving. If you're at Alaris and I'm at room 1 and somebody's at room 2, I'm just down the hall. And I say, look, I'll be right back. I just have to ask them one question. This is really going well. You go in, you come back. They're eagerly anticipating. They know where you are. They know what you're doing. That's harder to do with Zoom because you're there, you're gone. And they're just sitting around, sometimes by themselves in a room, and the momentum stops until you come back, and then they kind of pick up again. If you reach a settlement, this is getting into the harder part. When you reach a settlement, I have a form I fill out that says certain things: who will pay how much, what claim will be resolved, case will be dismissed with prejudice, who will pay the court costs, who will pay the mediation fees. I draw it all up. I ask people, this is what I'm going to put in. Is there anything you want? Do you want confidentiality? Do you want whatever they want in there? Check within a certain period of time. Let me know what you want. I will discourage you from putting it in the settlement if I can. One I get all the time is, we want the check within 20 days. I said, okay, what are you gonna do if you get the check in 21 days? You're not gonna settle the case? Of course you're gonna settle the case. Why do you want the check within 20 days? Well, let's just put it in there. Okay, fine, put it in there. I'll put it in there. And we'll discuss the terms generally with the plaintiffs first. What do you want in there? Then I'll go to the defendant before I write it up and ask them, these are the terms they want. Do you have a problem with a certain term? And if they have a problem with a certain term, I'll say, here's Erica's cell phone number. John, you call Erica, you deal with, and I had one where it said, we want confidentiality. I said, well, that's pretty general. They said, no, I settled the case with her last week. We used confidentiality language, the same one we used in the Smith case. So I call her up and say, can we use the same language you used in the Smith case? Yeah, sure, Smith case is fine. So I put Smith case mediation, Smith case confidentiality. Everybody goes, fine, we got it. Once they agree, then I write it up. I read it to the people, they agree to it. I read it to the other side, they agree to it. I take a picture of it with my cell phone and I text it or email it to the lawyers and say, read this and let me know this is what you've agreed to. And they will say, yeah, Tom, that's fine. Yeah, Tom, that's fine. There are two choices after that. I will take the email address of the plaintiff and the insurance adjuster and email it to those two and ask for 4 emails back, one from each lawyer and then the adjuster or the plaintiff to say, I have read the attachment, it's fine with me. As far as I'm concerned, that's an agreement in writing. It's never come up that I know of, but I consider it to be an agreement in writing. The better solution is to send it to Jen at Alaris. She can use DocuSign, which sends it to everybody. You use your fingernail or whatever you use to sign the bottom of DocuSign, send it back, and there is actually a signed document to use. So those are the topics that came to my mind when I was considering whether people should use a Zoom mediation. But the one thing above all, if you're going to use Zoom mediation and you haven't done one, find somebody who's done one and ask them if you can tag along.
Okay, awesome. So we have a few questions. I don't know if Erica and John want to, if there's anything else you want to address right now, or you want me to just ask these questions? What would you prefer?
Go into the questions.
Yeah, I think anything we have to say, we probably just won't bring it up.
Yeah.
Okay, and there's only 3 so far, but anyone listening, any of our attendees, if you want to add more, please feel free. So the first one is, with differences in streaming quality, all parties appearing from different locations, lag time, etc., how often are there errors in transcription, and how are those best addressed if discovered after the fact? And alternatively, if there is a lag or broken audio, is that slowed the speed of depositions requiring repeat clarification? So kind of 2 questions there. I don't know if you've had any issues with your transcripts yet at all.
I've not had any transcript-specific issues. I think that we usually deal with them as we go. I think the court reporters have been very vocal as far as if they haven't been able to catch something. And so that hasn't been really a practical concern. As far as streaming, you know, one practical tip that we really didn't talk about is you do have to be in an area where you have good Wi-Fi to do these things. And it's something you have to advise the witnesses. And you know kind of right away if you have a situation where you don't have a good Wi-Fi, they're in the wrong part of their house and something like that. And I think you have to address those in the front end. If you've got a deposition where everybody is choppy, it's not going to be a good depo. And you've got to be able to, you know, you don't want to waste people's time, but you have to be able to address those things, possibly reschedule even, you know, because it's a practical concern. So I think addressing those on the front end is the best. I have had just very limited situations where audio has cut out very briefly, and that's usually addressed by the court reporter. And it's gone fine, and I haven't had any transcription errors. And then as far as streaming, yeah, you really do need, as far as deposition practically, I know a lot of us are still in our houses. you have to have a quiet room with a good Wi-Fi. I mean, you really do. And if you can't get it, I do recommend you call up your local court reporting service and ask if they can get a room, because I know at least here, I have 2 kids at home. There is no way I'm taking a deposition in my house. Even if they know I'm having a deposition, something is going to happen. And there's a dog, my wife is working from the house as well. So I utilize court reporters' room. I use Alaris's offices when I can, find other locations when I can. I think as attorneys, and we have to advise our clients, we have to advise the witnesses of the practicalities of it and set some ground rules even beforehand. So I think a lot of those issues that are referenced in the questions, just you take care of them in the front end. And if you get into it and it's a problem, then you just take care of it then, I think would be the most practical solution. But really, I just haven't seen any transcription stuff yet. So I don't know.
Yeah, I haven't necessarily had any transcription errors. And the way we've addressed any anticipated issue with connection or having a quiet space to go for the witness is for Alaris to set up a room, and they've done that all over the country for us through their partners as well. So that's the way we've dealt with that. Think about that before scheduling a deposition and seek those resources if you need to. I think I took a deposition last week of a defendant, and the defense attorney had the defendant go to a hotel conference room, I think, and that worked perfectly. Yeah. So that was fine.
Okay. Or and just remember that either your staff or Alaris, if you're looking for locations, there's resources out there. So if you have someone who's like, well, I've got Wi-Fi, but I'm in a rural area, it's spotty. 20 minutes away is probably some court reporter's office. There could be relationships with attorneys. I had a thing down in southern Missouri where I called a guy I knew, and he had a conference room. He was willing to give it to me, and we had a witness appear there. I mean, things like that. I mean, it's kind of one of those things. Again, front end, just think ahead. You really don't want someone on their cell phone, on an iPad. You'd rather have them in a quiet space with good Wi-Fi on a laptop. And whatever accommodations you can, make to get that to happen, I would suggest you try to make that effort, because we've had situations where, like, the court reporter brings a laptop or something. I mean, there's solutions to these problems, I feel like, and I think you just really have to, just think about it ahead of time, and you usually could get there. So.
And I think for both mediations and depositions, having headphones, having headphones and with a mic is especially helpful, if that's a possibility.
Mm-hmm.
Oh, yes, I am a new owner of AirPods since we've all been at home. Thank you, COVID. That's fancy. Yeah, get them. They're worth it.
So another question, do you add any special language to the notice of deposition when the depo is via Zoom or WebEx?
We do. We have put the Zoom information, if we're setting up the Zoom meeting, and this goes for hearings, anything else you would set up by Zoom, we put the Zoom information in the notice, and we list where people are appearing. If we know a court reporter is going to be at a law office with a witness, we will notice it for the Simon Law Firm and via Zoom video conference. And that will be the 2 locations, if you will, that we notice the deposition. When we are filing the notice of deposition, when we're working with Alaris, they have then followed up that notice with an email to all parties with all the information they need. Often that email says to the attorney who's representing the witness, I don't have the email address for the witness. We are relying on you to share this information, which, go ahead and forward the email that you get to your client or the witness. And that's been easy enough.
So Erica, I think you touched on this one earlier. The person asked, are there electronic exhibit stickers available? I think you did touch on this. Do you create your own, or do you ask us to do it, or how do you do that?
Yeah, so my old version of Adobe, I had this function on Adobe myself. But now my paralegal, for some reason, only has the sticker technology. But there's 2 ways to do it. You can go old school and actually stick a sticker on your document and scan it in. I don't think that's as helpful just because of the scanning quality. And that document may not have all the functions of Adobe that John mentioned earlier as far as being able to highlight it. So I much more recommend There's a exhibit sticker like add-in that you can put on Adobe that will actually put an image of exactly what an exhibit sticker looks like, and you can fill in, you know, plaintiff's exhibit 1 or whatever. The other thing is, you don't even have to be that fancy. Go ahead and just insert text on your PDF through Adobe and just, I don't know, make it red and just put, you know,
exhibit 1 in the corner.
exhibit 1.
Yeah.
Yeah, I mean, it's that easy. It doesn't have to be an official sticker. I just don't like the sticker since we use that, but don't get caught up on.
I think it is an add-in for Adobe Pro or whatever.
Yeah.
So, and yeah, if you don't have it, I just recommend getting it because everybody's used to that. So that's what we use. We just have a.
Right. Another paralegal or another attorney will have that program and can send it on to you.
So the next question has to do with mediation. If Tom, you want to take this one.
Sure.
Are there special settings to open different rooms? How do you locate that portion of the app? I assume that they mean breakout rooms is what they're asking.
Only the host, as I understand it, can open up, create breakout. First thing that the host has to do is create the breakout room. You create up 1 to 9. You can create them manually, or everybody will, it says automatic, which means everybody goes into their own room. But only the host can do that. So the host sets up the number of rooms the host wants. People come into the
general session.
Yeah, they come into the general session and you explain to them what room they're going to go in. I'm not sure if I'm answering the question, probably not.
Yeah, I think that this person's asking is, do they have to do anything special? And I kind of joke when I do demos with people, you have the easy part. The neutral has the difficult part because they have control as the host. You just go where they put you, if you will. So.
When you log on, you will be in the waiting room. That was the word. Then the host will bring you into the general room. The host will put you into your breakout room. You just go where you're told. But it does raise one point. When the host puts you into your breakout room, you will receive a message saying, do you want to go into breakout room 1? And you have to say, yes, I will go. The mediator should tell you that so you know to expect, I'm going to get a message. It's okay to say yes. But no, you have no say over what room you go into. You can't switch from one room to another. Once I put you into your room, that's where you stay until I put you somewhere else, or unless you just log out of the mediation.
Okay, so I think we have time for one more. It's a 3-part question. So it has to do with deposition. So could you address any procedural quirks you have encountered? For example, making sure Zoom is not recording the deposition. I'm going to start with that one. I'll ask the other 2.
I think it advises you on your end if someone has hit the record button. So watch out for that. I haven't had anyone try that on me yet. But I think practically, you just have to watch out for that.
Top left corner, there's a blinking light that will actually say the word recording if someone has hit that. What I'm not sure about is if anyone other than the host can do that. And someone off screen is telling me no, they cannot. So only the host can call up the recording of the video. And when we schedule a deposition by video conference, the videographer is the one controlling that and has announced to us when recording will start.
It's a great segue into question 2. Could you follow up on how a remote videographer is used in addition to Zoom such that only the witness is on video?
My understanding is the witness can be what's called spotlighted. And so when you have the video recording, you don't get a picture of a screen with a bunch of all the attorneys, sitting over there looking at their email or something if they're not questioning. It is a view of the witness. And actually, the even really cool thing, I think that you may be seeing more at trial in the future when we're using these video depositions at trial, is if the witness is looking at an exhibit, you can direct or decide whether you have the witness's face and the exhibit right next to the witness, or the witness can be in the top corner while the exhibit is even being highlighted. So quite frankly, you can really structure your presentation to be a better trial exhibit if that is something that you're going to use at trial. So from my perspective, you can get as savvy as you want to, and with a little bit more prep, you can really create a nice presentation as you go through, and that just takes a little bit of practice.
So final question, we are running out of time. Eric, if you want to take this one, I don't know if you've experienced this where you have a client and you want to take a break and speak to them privately. How have you handled that in a deposition?
So that's a really good question, and I'm glad that was asked. I always prepare my client. Part of our prep for the deposition is going to be talking about how the Zoom deposition is going to run and what I'd like them to do when we go on a break. The most important thing, quite frankly, is asking them to both turn off their video and mute their video feed. And you can see that yourself. If you click on the participants button on the Zoom platform, it brings up a list and it shows everybody who is on the Zoom, everyone logged on. And you can do this right now and look at the fact that everyone likely has their little microphone with a red mark through it showing that they are muted, hopefully. And also, you know, obviously if their video's off, you can't see it. So I asked my client to go ahead when we take a break, mute your line and go ahead and turn off the video. And then we just talk on the phone if there's anything to discuss. And that works out just fine. I'm sure there's a way that you could ask to have a breakout room if you want to talk to your client face-to-face, and the host can run that. So that's an option that you can request if that's what you prefer.
Okay. That's a great answer. Thank you for that. So that concludes the questions, which is great. I did want to mention for those attendees that our marketing department in the follow-up emails will include links to Alaris's blogs and videos as resources for any further technical info. So if anybody's interested in that, it will be included. So thank you all very, very much, John, Erica, and Tom. This was very informative. I know we could probably talk about this for the rest of the afternoon. There's just a lot there. And if people are willing to reach out to you, or reach out to us, I will get those questions to you all, and I will share the feedback. So.
Yeah, and please feel free to reach out to me as well if you have any questions afterwards. I'm sure John feels the same, and Tom. So
sure,
thanks for attending, and sorry we're not here in person, but hopefully you think this went well, and it will inform your future video conferences.
So thank you. This will conclude the webinar.
Thank you.
Thank you.